Hello, students, and welcome to the lecture. So, students, as we know that we are covering the emergency provisions, okay? And basically, these are the topics we have scheduled for the discussion under this particular series, like the introduction, national emergency, parliament's approval and the duration, president's rule, financial emergency, and the criticism of the emergency provision. Okay? We have finished the introduction part, the national emergency. We have been discussing the parliamentary approval and the duration. And the topics we are completely left with is the president's rule, financial emergency, and criticism of the emergency provision. Okay, so we will start from where we had left in the previous lecture. I hope that you have revised the previous lecture in the well enough manner before you have come for this lecture. As many times I have told you, that is for your own benefit. So if you are doing this on the regular basis, the thing will be much more beneficial for you. So with this note, let's start from where we had left in the previous lecture. Okay, so we had discussed the declaration made so far in the terms of the national emergency. Basically, the first emergency was introduced in the 1962, second was in 1975, and the third one was in second one was in 1971, the third one was in 1975. Okay, and basically we had discussed that the 1962 emergency was in war or external aggregation. The 1971 emergency was also on war or external aggregation, and the 1975 one was on the basis of internal disturbances. Okay, and as per our discussion, we had come to know that 1971 and 1975 both emergency was declared side by side. Okay, both emergency was declared side by side, and that's why they were revoked in March 1977. Okay, thereafter, let's move ahead. The first two proclamation, both in the 1962 and the 1971, as I had told you, were made on the ground of the external aggregation. While the third proclamation, 1975, was made on the ground of internal disturbances. Okay, that is, certain persons have been inciting the police and the armed forces against the discharge of their duties and their normal functioning. Okay, the emergency declared in the 1975 was known as the internal emergency, proved to be the most controversial. Okay, why? Because that was basically politically motivated step. Okay, that's why that was a most controversial emergency. Okay, there was widespread criticism of the misuse of the emergency power in the elections held to the Lok Sabha in the 1977. After the emergency, the Congress party led by Narendra Gandhi lost and the Janata party became to the power. Like when the emergency was proclaimed in the 1975. Basically, the Congress party was in the force or in the power. But due to the emergency and the controversial move, or you can say the political motivated move, happened in the 1977, okay, the party lost its identity, and basically finally in the 77 elections, Janata Party defeated the Congress party and came into the power. Okay, This government appointed the Shah Commission to investigate the circumstances that warranted the declaration of an emergency in the 1975. The commission did not justify the declaration of the emergency. Okay. Hence, the 44th Amendment Act was enacted in the 1978 to introduce a number of safeguards against the misuse of the emergency provision. Okay. Like the Shah Commission, which was appointed. Okay. The main aim was to identify the valid grounds on which national emergency was introduced in the 1975. Okay. And basically, when the commission submitted their report, they said that there is no valid ground, and that's why they did not justify the declaration of the emergency. So, hence, the 44th Amendment Act of 1978, which was introduced in the 1978, that introduce a number of safeguards against the misuse of provisions of the national emergency, like to protect in the future no government which having the power to implement the emergency is able and allowed to use the emergency for their other purposes, or you can say simply misuse the emergency power. Okay. After the introduction national emergency, parliamentary approval and duration, we had the president's rule. That's the new thing we are going to start. Okay. So on which grounds the president rule could be imposed? The grounds of imposition. Basically, the Article 355 imposes a duty on the center to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. It means that it is the responsibility of the central government that they will ensure that every state government should work as per the provisions of the Constitution. Okay. It is the duty in the performance of which the center can takes over the government of a state under Article 356 in case of failure of constitutional machinery in the state. Okay. It means that if the central government is satisfied that the particular state government is getting failed to work on the basis of constitutional machinery. All right. So the Article 356 provides the power to the center that they could take over the state government of that particular state. And this is properly known as the president rule. It is also known as the state emergency or the constitutional emergency. Okay. So other two names of this is the state emergency or the constitutional emergency. Got it? Now let's move ahead. The president rule could be proclaimed under the Article 356 on the grounds one mentioned in Article 356 itself and another in the Article 365. It means that the president rule is having the two articles. Thirty-six, 365. Okay. So let's see them one by one. First is the Article 356. Empowers the president to issue a proclamation if he is satisfied that the situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the Constitution. Notably, the president can act either on a report of the governor of the state or otherwise too, therefore, even without the governor's report. So basically, if the president which belongs to the central level. He gets satisfied that okay, that particular state is not doing the work as per the constitutional provision. Okay, so he could pass the proclamation, or you can say issue a proclamation of the president rule or the state emergency, which is also known as a constitutional emergency. Okay, and this satisfaction could be come from the report of the governor of the state, like the state is not doing well, and even without the governor's report. Okay, it means there is no necessity that the governor's report is must. Okay, thereafter, Article 365 says that whenever a state fails to comply with or to give effect to the any direction from the center, okay, it will be lawful for the president to hold that the situation has arisen in which the government of the state cannot be carried out or in accordance with the provisions of the constitution. Okay, what does it mean? It means the constitution provides the central government a power that they could provide the direction to the state government. So if the central government provides some direction to the state government and the state government is not doing the work as per the direction, or you could say has been failed on the directions given by the central government, then it's depend upon the president to assume or to hold that the situation has arisen in which the state government is not allowed to carry out the provisions of the constitution. All right. Thereafter, another thing is the parliamentary approval and the duration. A proclamation imposing president's rule must be approved by both the houses of parliament within 2 months from the dates of its issue. Okay, it means that suppose not in January, suppose if that was presented in the March, so from March to May, total 2 months are provided within which the proclamation must be passed by houses of the parliament. Okay, if the proclamation is not passed within 2 months, the proclamation will be expire automatically. However, if the proclamation of president rule is issued at the time when the Lok Sabha has been dissolved, or dissolution of the Lok Sabha take place during the period of 2 months without approving the proclamation, then the proclamation survives until the 30 days from the first meeting of the Lok Sabha after its reconstitution, provided the Rajya Sabha approves it in the meantime. Suppose the proclamation was presented on 1st March, but the Rajya Sabha was ceased to operate. On 10th March, the not Rajya Sabha, Lok Sabha, okay. On 10th March, the Lok Sabha was reappointed. So from 10th March to 10th April, total time period of 30 days. Okay, the proclamation must be passed. Within these 30 days, if the proclamation is not passed by the Lok Sabha, then again the proclamation will be expired ultimately. Okay, but the provision could only be applied for 30 days if Rajya Sabha approves it in the meantime. Okay. Thereafter, if approved by both houses of the parliament, the president rule continues for the period of 6 months, can be extended for the maximum period of 3 years. The approval of parliament every 6 months is required. Okay. So, we had seen maximum duration of president rule for 3 years. Okay. That's the thing. Thereafter, however, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuation of the President rules, then the proclamation survives until the 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved its continuance. Every resolution approving the proclamation of President rule or its continuation can be passed by either House of Parliament only by a matter of simple majority. That is, a majority of the members of that house present and the voting. More than 50%. All right. The 44th Amendment Act of 1978 introduced a new provision to put restraint on the power of Parliament to extend a proclamation of President's rule beyond the 1 year. It means that the 44th Amendment Act of 1978 presents the condition that the previous maximum time period of 3 years is now shortened to 1 year. It means that for the maximum time period, the President rule could be, you can say, imposed for 1 year only. Okay. Thus, it provided that beyond 1 year, the President rule can be extended by the 6 months at a time or only when the following two conditions are fulfilled. Not President, sorry. When the following two conditions are fulfilled. And what are these two conditions? Let's see. First condition is that a proclamation of national emergency should be in operation in the whole of India or in the whole or any part of the state. It means that when the national emergency in the side corner is in the operation, covering the whole of India or any part of the state or whole state. Thereafter, the Election Commission must certify that the general elections to the Legislative Assembly of the concerned state cannot be held on account of difficulties. Okay. A proclamation of President's rule may be revoked by the President at any time by a subsequent proclamation. All right. Such a proclamation does not require the parliamentary approval. Okay. As in the case of national emergency. Got it? Now let's move forward. Consequences of the President's rule. Now, what are the consequences of the President's rule? First, the President acquires the following extraordinary powers where the President rule is imposed in a state. First power is that he can take up the functions of the state government and powers vested in the governor or any other executive authority in the state. Okay? It means that he could take up the power of both the state government and the governor's power and other executive authorities' powers which were available in the state. He can declare that the powers of the state legislature are to be exercised by the parliament. Like, he could take the state legislature power and could transfer it to the parliament. All right. Third, he can take all other necessary steps, including the suspension of the constitutional provisions relating to the any body or authority in the state. Okay. So these are the things. Therefore, when President rule is imposed in the state, President dismisses the State Council of Ministers headed by the Chief Minister. okay, which is the part of state legislature. The state governor, on behalf of the president, carries on the state administration with the help of the chief secretary of the state or the advisor appointed by the president. It means that the president will not directly start ruling the state, but he could appoint the governor as his representative and could even appointed the chief secretary or the state advisors, okay, for the help of the governor. Thereafter, this is the reason why a proclamation under the Article 356. Okay. Further, the president either suspend or dissolve the state legislative assembly. The parliament passes the state legislative bills and the state budget. Okay. Because the works which could be done by the state legislature are now to be transferred to the, you can say, the parliament. Why? Because the state legislature has been suspended. When the state legislature is thus suspended or dissolved, the parliament can delegate the power to make laws for the state to the president or to any other authority specified by him in this record. Okay. Second, parliament or in case of delegation, the president or any other specified authority can make laws conferring powers and imposing duties on the center or its officers and authorities. The president can authorize, when the Lok Sabha is not in session, expenditure from the state consolidated fund pending its elections by the parliament. And the fourth point is, the president can promulgate, when the parliament is not in a session, ordinances for the governance of the state. Okay. So these are the powers transferred to the parliament when the state legislature is suspended. And if the parliament is not in the power, then the president will use his own ordinance making powers in this case. All right. It should be noted that here that the president cannot assume to himself the power vested in the concerned state high court or suspend the provision of the constitution relating to it. Okay. Like state high court's power will be remain as it is and this could not be sustained. In other words, the constitutional position, the status, the powers and the functions of the concerned state high court remain same even during the president's rule. Okay, they could not be changed that easily. So what are the use of Article 356? Since 1950, the president rule has been imposed on more than 125 occasions, that is on an average twice a year. So how many times the president rule could be imposed or has been imposed? 125 occasions. Further, on a number of occasions, the president rule has been imposed in the arbitrary manner of the political or the personal reason. Okay. Hence, the Article 356 has become one of the most controversial and most criticized provision of the Constitution. Okay. Why? Because it is, you can say, said that the president rule most of the time has been implemented as arbitrary in nature for both political or personal manner. Okay. Now, what is the difference between the national emergency and the president's rule? Let's see. First, the article. National emergency is implemented by the article of Article 352. President rule implemented by the Article 356. Thereafter, it can be proclaimed only when the security of India or part of it is threatened by war, external aggression, or the armed rebellion. Okay, like only when the security of India or any part of India is threatened, okay, by the war, external aggression, or the armed rebellion. Whereas it can be proclaimed when the government of a state cannot be carried on in accordance with the provisions of the constitution due to reasons which may not have any connection with war, external aggression, and the armed rebellion. It means that this is just a constitutional failure. Thereafter, during its operation, the state executive and the legislature continue to function and exercise the power assigned to them under the constitution. A fact is that the center gets concurrent powers of administration and legislation in the state. It means that the state executive and the legislature is not suspended. But during its operation, the executive is dismissed and the state legislature is either suspended or dissolved. The president administers the state through the governor and the parliament make laws for the state. In brief, the executive and the legislative powers of the states are assumed by the center. All right. Thereafter, under this, the parliament can make laws on the subjects enumerated in the state list only by itself. That is, it cannot delegate the same to any other body or the authority. Okay, it means that if the parliament acquires the power, the parliament is required to discharge of. But when it's a president's rule, under this, the parliament can delegate the power to make laws for the state to the president or to the any other authority specified by him. So far, the practice has been for the president to make laws for the state in consultation with the members of parliament from the state. Such laws are known as the President Acts. It means that members of parliament will be in picture. Okay. 4. There is no maximum period prescribed for its operation. Can be continued indefinitely with the approval of parliament for every 6 months. There is a maximum period prescribed for its operation, that is 3 years. Thereafter, it must come to an end and the normal constitutional machinery must be restored in the state. Okay, so there is a time limit. Under this, the relationship of the center with all states undergoes a modification. Under this, the relationship only the state under the emergency with the center undergoes a modification. Thereafter, every resolution of parliament approving its proclamation or its continuance must be passed by the special majority. But every resolution of parliament approving its proclamation or its continuance can be passed only by a simple majority. No special majority is required. Affects the fundamental rights of the citizen, having no effect on the fundamental rights of the citizen. Lok Sabha can pass a resolution for its revocation. There is no such provision. It can be removed by the president only on its own. All right. So students, basically in this lecture, we have finished till here. In the next lecture, we'll continue from here. Till then, just revise all the facts and figures we have discussed in this lecture. Keep yourself ready for the next lecture. With this note, let's end this lecture, and what we say, thank you.